Afternoon. Good afternoon, everyone present here. On behalf of the organizing committee, I, Gaurav Dhakulkar, extend a warm welcome to all the distinguished dignitaries, faculty members, and participants of this faculty development program. It is indeed an honor to have with us our esteemed deans, Professor Dr. Nitin Pandey sir, Dean School of Law, GHRSTU, and Professor Dr. Farhat Khan ma'am, Dean School of Law, GH Raisoni University, whose constant guidance and support continue to inspire us. Today marks the third day of our faculty development program on the new education policy, a platform dedicated to exploring its vision, implications, and transformative impact on higher education and legal studies. Now it's my privilege to introduce this person, Dr. Pramod Tiwari sir, Senior Professor, Law Center to Faculty of Law, University of Delhi. Dr. Tiwari sir holds an LLB and LLM from Banaras Hindu University and a PhD from the University of Delhi. He brings with him over 14 years of rich teaching experience at both undergraduate and postgraduate levels. A former judicial officer in the Assam Judicial Services, Dr. Tiwari has published more than 40 research articles, edited 3 books, and contributed chapters to several academic volumes. He has presented over 50 papers in national and international conferences and has chaired more than 20 academic sessions across the country. Widely recognized as legal scholar and trainer, he has been invited as a resource person nearly 100 times by leading institutions, including UPSC, judicial academies, and public service commissions. His association with prestigious universities and public institutions reflect his deep commitment to legal education, research, and public service. We are indeed delighted to have him with us today. This insight. Now, I respectfully invite Dr. Pramod Tiwari sir to deliver his session on the topic of research strategies and techniques for law teachers. Sir, the platform is yours.
Very good afternoon to one and all. My heartfelt gratitude to the GS Raisoni Law School, in particular the Dean of the school, Dr. Nityanand Pandey, for inviting and delivering this lecture in this such a prestigious gathering. सभी लोगों को नमस्कार. Namaskar, sir. Am I clearly audible to you people?
Yes.
Sorry.
So now the topic which has been given to me for delivery is strategy for legal research. What are the various strategy and what are the various techniques which may be used by the law teacher in legal research? This is what the topic. Actually, topic is very vast, and I cannot claim that I have expertise over this particular subject. But let me tell you, I am the student of legal research. With the perspective of student perspective, I am going to gather information with the help of all the participants who are present over here. So now, legal research. Nowadays, legal research is become the, you can say, only to complete the research. We have to do something to complete the research. This is what a sort of fashion which is going on throughout the country in law schools. But perhaps it should not be. And that is why this topic which has been given to me is utmost relevant. What should be the technique which must be taken by the legal researcher? And what are the various stages of legal research? So that legal research may be scientific, may be very accurate, precise, concise, so that legal research may address to the particular problem which is in question. So for that, we have to discuss some very important points. Means how to start legal research. This is a big question, $1 million question. How to start a legal research? Legal research is not just a essay writing competition like. You have to select a topic and you have to write each and everything which you are finding upon that particular topic. No, legal research should be, there must be certain problem, there must be certain research problem. Unless and until there is research problem, one cannot proceed with the legal research. A very important point is identification of research problem. This is the big question. Now, what is research problem? Research problem means wherein there lies certain legal lacuna and which is addressed by the legal researcher. Only identification of research problem is not sufficient. No. There might be many research problem, but those research problem has already been addressed by certain researcher. Once that particular problem has been addressed by certain researcher, there is no need of further research, because that problem was there, but that problem has already been addressed by particular researcher. So now question is formulation and identification of research problem vis-a-vis identification of research gap. These are the two important points. For example, to illustrate, let me tell you all, if I am claiming that during a particular weather condition, body offenses are more in India. Let me illustrate more precisely. I am claiming that during summers, there are more body offenses which are committed. If this thing I am claiming as during summers, there are more body offenses committed, and during winters, there are more property offenses committed. So this is the problem in society which is prevalent. How to tackle this problem? How to address this problem? Because during summer season, more body offenses are committed by the criminals. So it is to be addressed. This is a problem in society, and it is to be addressed through law. But this problem is not alone sufficient for research unless and until there is research gap. Let me illustrate again. This problem has already been addressed by some legal researcher. There are many legal researchers who has done a lot of work in this point, and they have concluded that yes, during summer body offenses are more, and during winter property offenses are more. It means this research problem has already been addressed through research gap. So now we have to identify it. Is there any research gap? If I am saying that yes, there is research problem that body offenses are more during summers and property offenses are more during winters, it means in this particular topic, there was no legal research which has been conducted so far. In India particularly. If in foreign countries, something has been addressed by someone. Let me tell you some scholars in this point. I am telling about Cartographic School of Criminology, which is very well known school by all the legal scholars. So that is why I am addressing this particular problem, which is known to we all. In Cartographic School, although this school has been widely researched, and all the finding of this school has widely been researched by legal researchers throughout the country. Adolphe Quetelet and A.M. Gary, these are the two celebrated scholars from France and Belgium respectively. And they have addressed this problem as legal problem is there because during summers body offenses are committed more by the criminals, and during winter property offenses are committed more by the criminals. They have gone through why legal in particular point France and Belgium. But question is, in India, this problem has been addressed by any of the legal researcher or not, which is in this particular field. So that is why what I am trying to convey you all that we should identify the research problem, and mere research problem is not sufficient for research. Rather, we have to move a step forward wherein we have to identify the research gap. Is there any research which has been conducted by a particular researcher in this point or not? Now, how we can know that there is no research which has been conducted? We have moved to literature review. Unless and until we have reviewed the many literature, we cannot come across that how many work which has been done by a particular researcher in this particular topic. So research gap को find out करने के लिए we have to do legal means literature review. And in literature review, there are many steps. Those steps must be taken into consideration. Let me one has to gather the critical information about your legal issue. Once you are saying that there is a gap which is need to be identified, which need to be reached by a particular researcher. So for that, very first step would be one person, the researcher who is doing the research in this particular topic, that person must gather a critical information about the legal issue. Critical information. Now, to address this critical information, that researcher must identify if any research has been conducted in this particular topic or not. So for that, he have to see who have conducted this particular research in this particular topic, where this research has been conducted, what type of research was done, when this research was done, and what was the quantum of that research. So it doesn't mean that a particular research gap which has been addressed by a particular researcher, so now the task is over. No. A particular research gap has many components together, many components. So if a gap which has been addressed by a particular researcher, now again there are many questions. This particular gap was addressed where? If that gap was addressed in France and Belgium, but this has not been addressed in India, then India may research is required. So research gap, maybe again we have to narrow down the research gap, where it was conducted. Point number next, what was conducted? Actually, that gap which that researcher think in his mind, is that gap was addressed by that researcher in foreign country? This is also the second question. It might be I am thinking something else, and that researcher that doing little bit different thing, which I don't have in my mind. The question is, what was researched by him? This is also the point. After that, when this research was conducted, this is also a very important point. When? If that research was conducted in years back, and I am talking after 20 years or after 10 years or after 7 years, then perhaps there might be certain new legal issue emerged. So that is, this thing must also be taken into consideration. So research gap may be narrowed down by these methods. And next point is how, up to what extent this research gap was discussed by the researcher in the foreign country in that particular point of time. How? There might be many components of a particular research. Out of those components, that researcher has addressed only 2 or 3, but there are 10 components. So still we have 7 components which are left out in that particular research gap. So it doesn't mean that a particular research problem which has been addressed to a particular research gap, so task of research is over. No, task of research is not yet over. Rather, we have to see the critical analysis of that particular legal issue. And for critical analysis, we have to see who, where, what, when, how. These are the questions must be asked by the researcher. Then he can come across what actually the research gap is, which is required to be addressed by me. So this is the first step of literature review. Now point number next, when critical information has been gathered by the researcher, the second step would be that researcher would establish his own legal issue and his goal. My legal issue in this point, what I want to convey, what I want to contribute in the society. Does I want to contribute in the society, particularly regarding a fact? So if I want to convey this particular message, what is per body offenses? So it should be to establish my legal issue. Whatsoever other component which particular point of time, I don't have any concern with that, because my point is very specific and I have to address only upon that point. So this is what the next point, to establish our own and our own legal goal. to now again to narrow down this research gap, one has to forward, and that person have to learn and understand the precedent in jurisdiction. Is there any precedent which is prevalent in my research gap? For illustration, if I am saying that body offences are more committed during summer, it means, is there any precedent which has already been reached to this jurisdiction? So that precedent must also be kept in mind by the researcher. What I know and what I require to know in future, these are the 2 points. So what I know, that has already been done in this particular area, but what is needs to be discussed furthermore, what is required to be find out furthermore, this is what a particular point of research gap. It might be research gap is big, wherein some particular points has already been identified by the researcher in past, but now many other points are left out. So this is the next point, to learn and understand what is next to be find out in my legal jurisdiction. After that, researcher has to move forward to narrow down the research gap, and for that he has to determine the type of legal sources which he needs to address this gap. How many legal sources is required to reach to? Only primary sources are sufficient? Only secondary sources are sufficient? Only doctrinal research are sufficient? Only non-doctrinal research are sufficient? Means he has to see how many sources are there through which I may reach to my conclusion, which I have in my mind for this particular research gap. Moving forward, that researcher has to check that he is using the good law or not. It means, if I am talking about the effect of weather on criminality, then good law in this point is criminological school, particularly cartography school of criminology. So whether or not we are addressing the fundamental principle of cartographic school of criminology, that is what the good law in this research. If I am not addressing that particular fundamentals which are there in criminology, and I am proceeding in my research only, it means my research is not good. My research is not going in good direction. So one, the researcher has to check that whether or not he is using a good point. In reference to cases, if I am addressing a particular case law, then I have to keep in my mind, is this case law has already been overruled and new judgment has been pronounced by the court? If new judgment has been pronounced, I am researching about a particular legal principle which has already been overruled, then there is no requirement of such type of research. So that is why good law is the hallmark of good research. I am using the good law or not. So this must again be the task of researcher for identifying and to narrow down the research gap. And lastly, that researcher move to, he has to check the result. Whatsoever result I am going to incorporate. That result is to be checked by me during literature review for identifying the research gap. For example, I have to predict that there might be certain counterpoints. Whatsoever I am concluding in my research, what are the possible counterpoints? These are also very important. Because those counterpoints may be a sort of lacking in my research. So counterpoint must be in the mind of the researcher at the time of identifying the research gap. So this is the very first point which I am telling to you all, that research problem and research gap, these are the backbone of any research. Firstly, we have to identify the research problem, and from that particular problem, we have to identify the research gap. But that research gap might be very wide, and that research gap must be narrowed down by the researcher by these 5 or 6 steps during literature review, which I have conveyed to you all. So this is what the first point in strategic legal research: identification of research problem and identification of research gap. and do it narrowed down throughout the journey. This is the first problem. Once this first step is over, well begun is half done. It means if this thing has been done by the researcher, identification of research gap in precise and concise way, it means you are doing better research. Now you have to come up with your research hypothesis, because your research is very precise. You down your research gap, there is no overlapping, there is no possibility of overlapping at all, and now researcher has to move second step, that is what identification of research hypothesis. So hypothesis is the second step. Hypothesis is the central idea of entire research. This is the central idea upon which the entire research will revolves around. So that is why identification of research hypothesis after research gap. Let me illustrate research hypothesis. Let me illustrate from Delhi. Since I am residing here, I have a hypothesis in my mind that during morning and evening time, Delhi metro is overcrowded. This is my hypothesis. Now, in this hypothesis, if I want to move a particular research, yes, I have identified during morning and evening time, Delhi metro is overcrowded. Now, I have to address this hypothesis by research. Is it so? Is it so? Only morning and evening Delhi metro is overcrowded? Then I have to see during noon time, during afternoon time, whether or not same situation is prevalent in Delhi metro. If I am seeing that no, during noon time there is no too much crowd, only too much crowd in Delhi metro during peak office hour morning and jab office left out hoti hai during evening. So it means this is my research hypothesis as during peak hours Delhi metro is overcrowded. Now, after identification the hypothesis, I have to formulate the research questions. Research questions. क्यों ऐसा होता है ड्यूरिंग मॉर्निंग एंड इवनिंग, क्यों ऐसा होता है दिल्ली मेट्रो इज ओवर क्राउडेड? तो फॉर दैट आई हैव टू फॉर्मुलेट द रिसर्च क्वेश्चंस. नाउ आई हैव गॉन थ्रू मेनी books which are written on legal research. I have seen that writers have different opinion in this point. Few legal researcher and few writer of the legal research books are of the view that hypothesis, legal research hypothesis is to be identified by the researcher first. But few writers are of the view that no, legal questions should be formulated by the researcher first. Let me convey this message which I have gathered from the reading of those books. I have seen that one writer was of the view that he said that firstly problem came in the mind of researcher. Firstly problem came in the mind of researcher, and after that he reconstruct a research hypothesis. जो illustration मैंने आपको दिया, let me take the help of that illustration. During morning and evening Delhi metro is overcrowded. तो ये पहले हमारे दिमाग में आया कि पहले हमारे दिमाग में आता है कि why Delhi metro is overcrowded during morning and evening. These are the 2 points. तो सबसे पहले क्या होगा, when I went there in metro during rush hours, so I am seeing that as Delhi metro is overcrowded. So it means I have made a hypothesis. I have construct a statement which is untested, and I am saying that as during morning and evening Delhi metro is overcrowded. So this is what a hypothesis in my mind first, and after that question came in my mind, why it is so? Is it so because of office hour? Is it so because office just left? It is so because schools are going to be open in the morning? It is just because during evening time universities and schools are going to be closed? These are the many questions in my mind. So to me, research hypothesis comes first in the mind of researcher. He constructs a statement in his mind which is still untested, yet to be tested by further research. And on the basis of that research hypothesis, researcher move towards the identification of research problem. So there might be many research questions. To address that particular hypothesis, there might be many research questions, 1, 2, 3, 4, 5. And as many research questions are there, as many research objectives would also be there. Because every research question must be correspond with every research objectives. So research objectives and research questions are corresponding to each other. And these research questions and research objectives must leads to research hypothesis. ये किधर की तरफ जाएंगे? They will move towards, all the questions and all the objectives should move towards research hypothesis. And this research hypothesis came from where? This is research hypothesis came from research gap. And this research gap, which I have identified, it came from where? It came from research problem. So these are the very synchronized, means you can say components. Research problem say research gap say hypothesis, hypothesis say question, question say objective. So these are the 4 or 5 things which must be identified by the researcher in very synchronized way. It doesn't mean that my research hypothesis is moving towards north direction and my questions are moving towards south direction. No, this is not good research. In the same direction wherein my research hypothesis is moving, in same direction my questions objectives should also move. Then only I can reach to the right conclusion of my particular research which I'm about to conduct. So these are the 4 or 5 components which must be keep in the mind by the legal researcher for systematic and strategic research. He have to come across a particular legal problem. Legal problem must be narrowed down through legal gap, research gap. That research gap must be narrowed down by literature review. And after identifying the research gap, legal researcher must formulate the research hypothesis. On the basis of research hypothesis, research questions must be formulated, and every research question must address to particular research objectives. If all these things are done, and if researcher is quite clear what I have done with the extensive work, extensive reading, extensive research, it means that researcher has done very well in this particular research. So this is what scientific and strategic research. So for that we have to do all these things. Now question is, although I have and one researcher has identified his hypothesis, formulated the research question, formulated the research objectives, gap has already been identified. Now to address this research hypothesis, either to prove or disprove it at last of the research, there are many tools and techniques which must also be adopted by the legal researcher. What are those tools and techniques? Let me tell you. There are many points which must be in the mind of legal researcher to address that hypothesis, either to prove or disprove at last. क्या क्या होना चाहिए उसके दिमाग में? How to find books and law journals, because without books, without law journals, he cannot either prove or disprove his research hypothesis. The first question should be in the mind of the legal researcher is how to find the books and law journals. After that, second question should be how to find legislative intent. If I am addressing a particular legislation, a statute, then researcher must keep in his mind what was the intention of the legislature. Next question must be how to find the case laws to address my research hypothesis in totality. How to find the constitution of different countries if research relates to constitutional issue. How to find. Point number next would be where to find and how to find the commission and committee's report, which might also assist the legal researcher during his entire work. He must also keep in his mind how to find legislations and statutes. He must keep in his mind how to find parliamentary debate, parliamentary discussion, or parliamentary committees, if any, which is applicable to his research. After that, treaties and international agreement, written treaties at international level, treaties at international level, and international agreement if research relates to international law. Not last but not the least, he must also identify where from he may gather the dissertations, PhD thesis, and seminar reports. So these are also the tools through which he may address his legal research. So these are the many points which must be kept by the researcher in his mind. Now let us discuss one by one how to find books and law journals. If this is the question, how to find books and law journals, if you see, if you are the legal researcher, you have identified your research hypothesis or research objective and questions, then you have to search the materials. So books are very well arranged and well arranged in a classified manner in every library. If you see the subject index A, B, C, D up to Z, you can find what is your area of research. You can go to the library, you can find as per the subject index, and you may find the relevant books and law journals which are kept by the library, your concerned library. Now, there is a method of library system I have seen here at Delhi University, wherein they are following the universal decimal classification system through which they have arranged their library so far as books are concerned. So you can very easily go there, and as per that system, librarian will tell you, yes, this book is kept at that particular place. Otherwise, library is very huge. So your big means time of your research might waste in the search of these books and law journals. So that is why universal decimal classification system is specially designed for arranging the research library, books, and other reading materials is used in law library. So this is very important, which must be known to the researcher, how to identify, how to search the research book and law journals which relates to my research. After that, second question, which I have told you just few minutes back, how to find legislative intent. So if researcher wants to find out the legislative intent, then the legislative intent of any provision can be ascertained with the help of many tools. Many tools. For example, object and regions of an act, or if that particular document is bill, then bill. What is the object and regions? After that, parliamentary debate. When that particular statute was enacted or going to be enacted, then what was the parliamentary debate? Debate and discussion by the legislature, member of legislative assembly, if at the state level, or member of parliament, if at the central level. That must also help a particular researcher to find out what was the legislative intent of this particular statute. After that, that legal researcher must move towards the law commission report, if any. Is there any law commission report? What was the recommendation of law commission regarding that particular statute? For example, if we take the example of Constitution of India, and if there is a research which is conducted by the researcher upon particular point of Constitution, then that researcher must go through the Constitution Review Committee report, which was widely reviewed the working of Indian Constitution in late 2002. And after that, many committee recommendations are there. So that is why law commission report committee's recommendation must also be looked into by the researcher. After that, to find out the legislative intent, researcher must rely upon standing committee, joint committee, select committee report of the legislature, if any. Last but not the least, to find out the legislative intent, legal researcher must go through the reports of the committee appointed by the ministers for enacting or reviewing any existing enactment. If review ke liye, if committee has been constituted, then what was the opinion, what was the recommendation, what was the, you can say, outcome of that particular report, which has been given by that expert committee. That must also be looked into by the researcher for extensive research in this point. So in this way, researcher may identify what was the legislative intent in this particular point. Now, next point is how to find a legal articles. If I am conducting a research upon a particular point, I have formulated my hypothesis, question, objective. तो उसको साबित करने के लिए या ना साबित करने के लिए हमको लीगल मटेरियल रिक्वायर्ड होगा. तो बुक और एस्टेच्यूट के अलावा आई हैव टू मूव टुवर्ड्स लीगल आर्टिकल्स, एंड फॉर दैट we have indexing and abstracting system in library. Indexing and abstracting, somewhere you can find through topical index articles are arranged by the law library, you can search very easily, or somewhere you can find abstracting system is there through abstract whatsoever abstract was that of that particular article, accordingly they have arranged the research article in their library. So either you may find indexing system or you may find abstracting system through which you may gather the information for your research from legal articles. And if you talk about online databases, then you can find that there are many databases which are available to find out the legal articles. For example, let me enumerate few. Westlaw International, JSTOR, we have Social Science Research Network, we have Global Legal Information Network, we have LexisNexis online database. So these are the many databases through which legal researcher may identify how many research articles are available for conducting the smooth research. Now next task of the researcher would be, उसने बुक देख लिया, उसने लेजिस्लेटिव इंटेंट पता कर लिया, उसने रिसर्च आर्टिकल भी गैदर कर लिया. आफ्टर दैट नेक्स्ट स्टेप ऑफ द रिसर्चर वुड बी how to find case laws, because cases are the backbone of legal research. Unless and until you are come across with the recent judgment which has been pronounced by the Supreme Court and High Courts, you cannot do the good research. So that is why how to find case laws. Now case laws ke liye you may have glance over, being the researcher you may have glance over the foreign reports as well as Indian law reports. So if you talk about foreign law reports, you can find there are plethora of foreign law reports which are available at public domain. For example, we have All England Law Reporters. You can have online access, you can have offline access for your legal research. We have Australian Law Review. We have Canadian Supreme Court reports. We have Commonwealth Law Report. We have Dominion Law Report. We also have Federal Law Report. We have English reports. We have law reports, reprint, Rainbow Series, 1874 onwards. This is also available. We have US Supreme Court report. We have weekly law reports, etc. So there are many foreign law reports which are available through which you can search the cases which has been decided by foreign countries, courts of foreign countries. If they are going to assist your research in any way, you can take the help from all these reports for systematic and strategic research in law. After that, you can have glance over the Indian law reports. For that, we have number of reports. You all are perhaps come across and you all are perhaps knowing all these reports. Supreme Court reports, Supreme Court cases, we have All India Reporters, we have a scale as a legal journal, SCALE scale, we have judgments today, we have Indian law reports, we have law reports of all the states separately, 28 states. So these are the many law reports which are available and which are you can identify at public domain, through which you can assist your legal research. So this is the method through which you can find out the cases which has been decided either by the foreign country or by Indian courts. Next point for the legal researcher would be for systematic and strategic research, how to find the constitution of different countries. Irrespective of the fact that your research relates to constitution or not, but since we all know that constitution is the supreme law, and that is why our research must be supported by the constitutional principles which are there in India, and it must be compared with the constitution of other federal country to which India is addressed to. So for that, we have to find out the constitution of different country. For that, we have constitution of any country of the world and may also be downloaded from the various websites. So there are various websites available. You can search at the public domain, you can find, and from those websites we can download the constitution of different country and you may take those constitution as assistance of your legal research. Now, next task of the researcher would be where to find commission and committees report. Where to find commission and committees report? So in India, various commission and committees are in existence, like Women Commission, we all know, like Commission for Scheduled Caste and Scheduled Tribe, we all have come across, National Human Rights Commission, we all know. So these are the various commission and committees which are available and which are prevalent at the institutional level. Now, reports of such commission are maintained within the law library collection. If you see, you can find the Human Rights Commission report everywhere in every library. Parliamentary committee reports are also the major source of legal information, which may also be referred through the website of the Parliament of India. Anytime you can find. Annual report of the government department is also useful for the legal research. So these are the many things, many sources through which legal researcher can find out the commission and committee reports, and he may take the assistance of these commission and committee reports in his legal research. Now, next step for the legal researcher would be how to find legislation. How to find legislation? Legislation may be the legislation of India, legislation may be the legislation of foreign country. So how to find all these legislation, bills and acts of the concerned parliament, like US Supreme Court Code, like General Public Act of United Kingdom, like Australian Consolidated Commonwealth Act, like AIR Manual in India, other Act of Parliament, Civil Code Digest, Gazette of India, current central legislation, current Indian statute, etc., act and legislation of all the countries, and also provided through online services. Yes. So there are many online services available through which you can find the statute and legislation and bills which are either pending or passed at the foreign level or even at Indian level, at the central and state level. So all these things are also available through online platform, very widely public domain. Now, next step of the researcher would be parliamentary debate and parliamentary committees. How you can find the parliamentary debate? For example, once I am doing a research on constitutional issue, then I have to have glance over the Constituent Assembly debate, how to find this Constituent Assembly debate, where it is kept, it is there in the library or not. These are the $1 billion question which might be in the mind of researcher for systematic and strategic research. So parliamentary debate may be downloaded from the website of the Parliament of India from 11th Lok Sabha 1996 onwards. So all these 11th Lok Sabha onwards, all the parliamentary debates are available. All parliamentary committee reports are published by the Parliament of India and also browsed to disseminates a student within the library through online access. Electronic version of the command papers, debates of the House of Lords and House of Commons are also available on the website of United Kingdom Parliament. So these materials are also available. There are certain databases, there are certain links, certain websites through which you can find the parliamentary debates, parliamentary committee reports, etc. and etc., which might assist your legal research. Now, treaties and international agreement, if any, which might assist your legal research problem and research hypothesis. So you may search all these things. Law library में भी आप देख सकते हैं, and online platform पे भी these treaties and international agreements are available. Now you may search the seminar reports, thesis, and dissertations. Law library is specially supporting the university system to maintain the international and national seminar reports concluding inside and outside the country. Not only that, digital version of these reports may be preserved within the law library. Thesis and LLM dissertation submitted with the research scholars may also be useful for legal research. So once I am doing a particular research, it is not necessary that I have to gather only books, research article, website material, commission committee report, parliamentary debates, statute, in legislative intent. Apart from that, I may also have glance over certain dissertations which has been submitted at LLM level. Our researcher may consult the research thesis which has already been submitted by a particular researcher on the similar topic. Not on the same topic, because the research gap necessarily should be different, but you can take the help from those research means LLM dissertation and thesis to conduct your research. So these are the many materials through which a legal researcher can take help too. Now, apart from these materials, either primary and secondary sources which we have already discussed, to address the research hypothesis, research objective and questions, next question should be in the mind of the researcher for systematic research is legal citation. How citation is to be met. This is also a component of strategic legal research. How book is to be cited. There are many methods which are prevalent throughout the world. Many methods. For example, we have American Chemical Society's style of footnoting and citation. We have American Psychological Association style of footnoting and citation. We have a style manual for political science for citation and footnoting. We have Blue Book style for citation. Not only that, we have Chicago Manual of Style for citation. We have Columbia style for citation. We have MHRA style. MHRA, popularly known as Modern Humanities Research Association style. Modern Humanities Research Association style, which is also applicable in law. This is also available. This is also one of the style for footnoting and citation. We have MLA style, which is known as Modern Language Association. Modern Language Association style of footnoting and citation. So these are the many footnoting and citation style which are available throughout the world. So how book is to be cited, how journal in legal article in law journal is to be cited. So for that we have certain rules and regulations in these styles. For example, if book is to be cited, then firstly the name of author is to be written. After that, the title of book is to be written. After that, volume, if any, is to be identified by the researcher. After that, edition, which edition this book relates to which edition. After that, publisher, कौन publisher है इसका, year of publication, and page number. So these are the many things in this chronology. The book is to be cited in the legal research. Similarly, once you want to cite a particular article which is published in the law journal, then again, what is the name of author? What is the title? Here title must be in inverted comma and italics होना चाहिए. After that, year. After that, volume. After that, name of that particular journal and page number. So these are the components to cite a legal article which is published in legal research. Similarly, electronic resources website or hyperlinks से अगर आप जाते हैं, then what is the method? Then again, author's name, title, year, volume, periodical, what is the general name, and lastly URL must be pasted by you. Cut and paste. You may copy and paste there, and lastly visited on this and this date, so that it can be identified when you have visited that particular URL. So this is also the method of citation for electronic sources. After that, we have many other sources which can be used by the legal researcher as a citation and as a footnoting in his legal research. For example, All India Reporter. If case which has been decided by the Supreme Court and which has been published in AIR, then citation का method क्या होना चाहिए? A versus B, AIR this year, Supreme Court this and this page. Versus में V should be small dot, a small dot. So these are the certain nuances to cite the cases which has been reported in All India Reporter. If cases reported in Supreme Court cases, then method would be X versus Y, year within bracket, after that volume, after that Supreme Court cases, and lastly page number. Similarly, Supreme Court reports, then again SCR, the party's name, and after that year within bracket, volume, and Supreme Court report, insert SCR and page number. So this thing should be taken care of by the researcher. If Supreme Court journal, if your case is published in Supreme Court journal, then SCJ, Supreme Court journal, must be cited at the place of SCCIR, etc., which I have already told you. If your case is reported in criminal law journal, then CRLJ, we all know. So these are the method of citation of cases. If a researcher want to cite the legislative materials, for example, if I want to cite the Right to Information Act, and I want to say that case, I have taken these lines from the Right to Information Act or Right to Information Bill when it was pending in late back in year 2004. Then how I supposed to cite this particular bill? Right to Information Bill 2004 within inverted comma, introduced in Lok Sabha on 22nd December 2004 inverted comma closure. So this would be the complete information, not only the Right to Information Bill 2004. No, this is not suffice. If I want to cite a statute other than bill, then for example, take the illustration of Right to Information only. So Right to Information Act 2005 within bracket number 22 of 2005 dated 15th May of 2005 bracket closes. This is what the full name of Right to Information Act 2005. It is not कि I may write only Right to Information Act, comma 2005. This is sufficient. No, you have to write within bracket number, कौन सा number था 2005 का, और इसके बाद ये लोकसभा और पार्लियामेंट में कब पास हुआ, तो that particular date must also be cited and it must be kept within the bracket. So that is what the method through which act and statute is to be cited. Other legal materials, book है, monograph है, treatise है, etc. is to be cited accordingly. If newspaper you want to cite newspaper, so for that also we have different method. Firstly, we have to write the name of the author, after that title which he have written, after that name of the newspaper, for example the Times of India in italics within bracket New Delhi, after that the day, Tuesday, Monday, whatsoever you have to write, after that month and date, for example November 24, whatsoever, after that year, if this is year 2025, then 2025, comma, page. So this is what the method through which you can cite the newspaper. If you want to cite the conference and seminar papers, so again the method is enumerated there, how you can cite the conference and seminar paper. So these are the many methods which must be help the researcher to do the systematic and scientific legal research. So these are some points which must be taken care of by the legal researcher. Now let me tell you, if we want to do a research upon a particular point, so what should be in the mind of the researcher? For example, if research is committed by the researcher on fundamental duties under the Constitution of India, fundamental duties, for example, so one can say that key rights and duties are correlative to each other. If any law of the land which incorporates rights within it, then duties must also be there. So far as Constitution of India, if you find, we had the fundamental right from the very beginning, but for duties our Constitution was silent, and it was added in 1976 by the virtue of 42nd Amendment, we all know. Now, if this is the point, a researcher may think that why it is so. Why fundamental rights were incorporated by the forefathers in the Constitution, but duties were missing? Why it is so? Irrespective of the fact that we are the country who are the follower of fundamental, we are the flag bearer rather, not only follower, we are the flag bearer of fundamental duties from centuries together. Karmanyevadhikaraste. So we are the flag bearer of duty. But even then our Constitution was silent about duty in the original text, and it was added after 26 years in 1976. If this thing in the mind of researcher, and if you want to do research in this particular point, why it is so, then you have to go through the fundamental duties incorporated. If you see the length of fundamental rights, you can find that big length has been assigned by the Constitution to the fundamental rights. Big length. Fundamental right 1, 2, 3, 4, 5, 6, earlier 7, now 6. Very big length of fundamental rights. But so far as fundamental duties are concerned, only one article which has been assigned by the Constitution to it. So now question is, why this is long gap? Why not rights corresponds the duties, because rights and duties are correlative to each other. If you have glanced over the jurisprudential aspect, you can find the Hopfieldian classification of legal right in wider sense, wherein Hopfield has said, bracket wala formula, if you keep in your mind, you can find that right and duty, they are in vertical relationship, and these vertical relationship, they are dual correlatives to each other. If rights are there, duties are bound to be there, and at the same extent and at the same length. But why it is not so? This is the point. If researcher want to do the research in these fundamental duties, then he have to read the fundamental duty. Why I am telling all these things in fundamental duties? Because once you want to do the research upon a particular point, you have to know the pros and cons of that particular point with the legislative history. If you read the fundamental duties which are incorporated in the Constitution of India, although very less decision, very less argument and counter argument was there before the Supreme Court of India since inception. But even then, if you read the lines which are written, they are very wide, and they may incorporate, they may correspond all the lengths of fundamental rights in India. So once you want to do a research upon a particular point, you should not only act on the proposition, only research upon the supposition. No, you have to read the letters. Within the words, you blink your mind within the words, so that you can identify what is written there and what is to be addressed. So for example, these fundamental duties, if you see, just I am reading few of them. Fundamental duties, for example, we have 51AG, to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures. So these are the points which are written here. It means these are not mere forest, lakes, no. These are the values of Indian tradition and culture. Forest, trees were worshipped from India from centuries together. मूले ब्रह्मा त्वचा विष्णु शाखा शंकर मेव च पत्रे पत्रे देवानाम देवराज वृक्षराज नमस्तुते. It means, if you see, you can find that trees were worshipped in India from centuries together. Not only trees, animals, living creatures, they are worshipped. हम एनिमल्स की पूजा करते हैं, हम पानी की पूजा करते हैं. We means kept Ma Ganga at a high pedestal. It means Jal is also a thing of worship in India. In this way, if you see these clauses which are incorporated in fundamental duties, you can find that these fundamental duties have very long length, and they may correspond the fundamental rights which are there in the Indian Constitution. So it doesn't mean that many critiques and many criticism I have seen, few research topics I have seen in this particular point, wherein research topic has been created and has been formulated by the researcher in fundamental duty. And he was of the view that few days back I have seen this particular topic, and that is why I share my opinion, my thought to you people. That researcher was of the view that fundamental duty needs to be expanded. It must correspond the fundamental rights at length. Otherwise, many judgment which has been given by the Supreme Court for protection of fundamental right, but very less judgment which has been delivered by the Supreme Court for the implementation of fundamental duties in our constitutional fabric. Why it is so? So, taking into consideration all these, note that researcher has formulated the topic of research on fundamental duty. Now, question is, you should not only formulate the topic of research. No, you should read first. So whatsoever statute, whatsoever means thing which you want to do the research, you must keep in your mind, yes, these are the things which are incorporated in that particular topic. Otherwise, तो फिर research का क्या मतलब? So firstly, you should go through the very depth of those particular points and then address the situation. So this is what the point which I want to convey regarding technique and strategy of legal research which has been assigned to me, wherein I have told to the participants that the first and foremost task of the researcher is to identify the research problem, and after that to identify the research gap and narrow down the research gap, and after that he has to formulate the hypothesis. From that hypothesis he may reach to the questions and objectives, and after that he may move towards the systematic research through resources. Through resources, how to find the book, law journal, how to find cases, etc. and etc. When everything has been researched by him, then he may address his research hypothesis and reach to the conclusion. And lastly, I have conveyed that if particular topic is to be researched by the researcher, that researcher must read in depth that particular thing. And that is why I have given the example of fundamental duties. Few days back I have come across. So once you want to do the research upon fundamental duties, firstly you should read the fundamental duty. Not only the black letter which has been written in the constitution, rather the very soul of the fundamental duties, in the umbrella of which all these duties are incorporated. And then only you can give your opinion and you can formulate the hypothesis and accordingly come to the conclusion. So this is all about this particular topic on my side. Now, if any participant want to have any conversation, want to have any question in this topic, I'm glad to. Thank you so very much.
Thank you so much, sir, for such a thought-provoking and enriching session. Your insights on research strategies and techniques for law teachers have truly broadened our perspective and provided us with practical approaches for academic growth. We will now take up a short question and answer session. I request participants to kindly raise their questions to which Dr. Tiwari sir will answer. If anyone have questions, can raise their question.
You may write your question in the chat box also. How many participants are there, by the way, because I am not in position to identify who are attending this program.
There are about 32 participants.
Okay, but it is not visible to me. No, it is visible. I am not in position to. मैं नहीं देख पा रहा हूं कितने लोग हैं. Anyway,
If there is no question, we can move forward. Now, it is now a privilege to invite esteemed colleague Mr. Adesh Pandey sir to deliver the formal vote of thanks. Adesh.
Good afternoon, everyone. Good afternoon. Now, sir, am I audible? So, good afternoon to everyone present here. On behalf of the organizing committee of this second development, I want to extend my sincere gratitude to our distinguished resource person for today, Dr. Pramod Tiwari, sir, Senior Assistant Professor, Faculty of Law, University of Delhi. Sir, your session on research strategies and techniques for our law teacher has been insightful and deeply enriching. Your practical guidance on approaching legal research and your vast academic experience have provided valuable perspective to all of us. I also wish to express my heartfelt thanks to our respected deans, Professor Dr. Nityan Pandey, sir, Dean School of Law, G.H. Raisoni Skill Tech University, and Professor Dr. Farhat Khan, Dean School of Law, G.H. Raisoni University, for their constant encouragement and support. My appreciations extend to all faculty members, staff, and participants for their active involvement in making this program a success. With this, we look forward to carrying the learnings from today's session into our academic and research practices and to the continued exchange of knowledge in the upcoming session. Thank you once again, Dr. Pramod Tiwari, sir, for your time and expertise in this session.
Thank you so very much to organizers, in particular the Dean School of Law, Dr. Nityanand Pandeyji. Thank you so much. Namaskar.
Thank you, Mr. Adarsh sir, for expressing gratitude on behalf of all of us. With those heartfelt words of thanks, we are now formally bringing this session to close. Before we disperse, I kindly remind all participants to fill out the feedback form, the link of which has been shared in the chat box. Your reflections and suggestions are invaluable in shaping our future initiative. We sincerely appreciate your time and active involvement, and we look forward to your presence in the upcoming sessions of the Faculty Development Program. Thank you, everyone.